Am I free to go?
I want my lawyer now.
I want a lawyer right now.
Mr. Nolan, it's for you. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law. Welcome back. Windshield time. I guess it's kind of like a desk time. I don't have to go anywhere today, but we have something that I think we need to do, and I wasn't going to wait for a weekend shooting session to do it. I want to talk today about electronic evidence and electronic evidence collection. That's something that happens in many, many cases, both criminal and civil, and it's extremely important. I've had some cases where I've been defending people, and we've looked to their Google records and that to see if we had an alibi from their phone tracking, so we could see if their cell phone said they were somewhere else when police said that they were in one place. And that does pan out sometimes. Google is a snitch in your pocket. So let's talk about this for just a moment. When detectives in a Phoenix suburb arrested a warehouse worker in a murder investigation last December, they credited a new technique with breaking the case open after other leads went cold. The police told the suspect, Jorge Molina, that they had data tracking his phone to the site where a man was shot 9 months earlier. Now, they made the discovery after obtaining a search warrant that required Google to provide all information on devices it recorded near the killing, potentially capturing the whereabouts of anyone in the area. The warrants, they can draw on Google's enormous database that the Google staff calls Sensor Vault. It turns the business tracking cell phone users' locations into a digital dragnet for law enforcement. You know, in this era of data collection by tech companies and everyone else you deal with online, you know, it's the latest example of how your personal information is being used for purposes that people don't expect. Now, the practice was first used, as reported in a newspaper in 2016 by federal agents, according to Google employees, and it was first publicly reported last year in North Carolina. Since then, it's been used in police departments, local departments across the country, including California, Florida, Minnesota, Washington. And Google employees say that they receive as many as 180 requests per week from police departments. Per week. Now, the orders, they can be called geofence warrants. They specify an area, a geographical area, and a time period. And then Google gathers the information from the sensor vault about the devices that were there. Now, Google claims to protect you by labeling those with anonymous ID numbers. Then the detectives look at the locations and the movement patterns to see if any appear relevant to the crime. Once they narrow that field to a few devices they think belong to suspects or witnesses, Google will reveal those users' names and other information. The geofence warrant is similar to, but much more intrusive than a cell tower dump warrant. Now, a tower dump warrant is served on a cell phone provider or all cell phone providers in an area for information about a particular time and tower or series of towers. The government has taken the position for years that cell tower information belongs to the cell phone company and not to the suspect. It's merely business records maintained by the cell phone company. And that information can be shared, according to the government, with law enforcement without a search warrant. However, in 2018, the U.S. Supreme Court disagreed with that, and while permitting a tower dump case to proceed, held that a warrant was required to compel the production of data from the cell company. A recent case in Central Virginia, a man accused of bank robbery challenged a geofence warrant served on Google for data related to users of Google's location services near the location and time of the robberies in question. Commonwealth of Virginia argued that the geofence warrant was reasonable because the suspect opted into Google location service. A news report described it. Google first provided location data but no identifying information for 19 devices in a 150-meter radius around the bank for a 1-hour period that included the robbery. Police then picked out 9 of those devices for more information. Google gave location data on those devices covering 2 hours. Finally, the police asked for and received subscriber information for 3 devices, including one that was in the bank during the robbery, left immediately after it, and followed a path matched by witness sightings. That gave police the defendant's email address and told him he used an Android phone and Google location history, which tracks users' movements and is viewable in Google Timeline. And that's what I mentioned earlier, that I've had some cases where we've used that Google location history in the timeline to attempt to establish that my client had an alibi and was somewhere else. The Constitution provides that a warrant must be specific, okay? You have to specify the place to be searched, the thing to be seized, okay? In this case, the place to be searched is Google. And the thing to be seized is their subscriber records for anyone near the scene of an alleged crime. Unlike a normal warrant, which we have a suspect and believe that they possess the evidence we're searching for, a geofence warrant is used against a massive database. There is no suspect and we want to find one. That's a problem. It searches information mostly about innocent people and provides that over to law enforcement. It's a tower dump multiplied by a factor of 100. And the records that they're seeking are collected and stored indefinitely by Google. They can be used to solve murders, rapes, bank robberies. They could also be used for speeding, parking tickets, other violations. And you get the NSA involved, and the government can, with a warrant, get records not just about a specific crime, but all location records that can be used later to solve crimes, or even for political purpose to determine which one of you commie bastards are, subscribing to red philosophy and should be locked up. I mean, this could happen. Or the alternative, which one of you conservative people is going to a Republican meeting and should be locked up because you're a danger to society. This can be and is being used inappropriately. So if they have a suspect, then they can use that location data and geofencing to find out who they met with, when they met with them, where they met with them. Have I mentioned yet, or have you gathered that we're basically carrying surveillance devices with us at all times? I mean, I'm recording this on mine. I'm sure the NSA's got a copy of this right now before I even posted it for you. Look, the data that Google's turning over to law enforcement is so precise that a deputy police chief said it shows the whole pattern of life. Okay, it's collected even when you aren't making phone calls or using apps, which means it's more detailed than the data that's generated by cell towers. Now, this technique is problematic for several reasons. First, unlike other methods of investigation used by the police, they don't start with a suspect or even a targeted device. They work backward from location and time to identify a suspect. Now, this is a fishing expedition. It's the exact kind of search the Fourth Amendment is intended to prevent. Searches like this, where the only information police have is that a crime has occurred, are much more likely to implicate innocent people who just happen to be in the wrong place at the wrong time. Essentially, this is saying that there was a car stolen in downtown Kirksville, Missouri. So if you were in downtown Kirksville, Missouri yesterday, you are a suspect. And now you've got to clear you. That's not the way our system is supposed to work. And largely it isn't the way it works for a lot of reasons and a lot of people. So with this, every device owner in an area during that time at issue becomes a suspect for no other reason than they own a device that shares location information with Google. Second, as the Supreme Court recognized in Carpenter v. United States last summer, detailed travel data can provide an intimate window into a person's life, revealing not only his particular movements, but through them his familial, political, professional, religious, and sexual associations. And that's exactly what that police chief mentioned earlier. It's what he meant, that the Google location data shows the whole pattern of life. So this is a very significant problem. Clearly, if you know you're going to be breaking the law, don't carry your goddamn cell phone with you. But we have issues with this electronic data collection, and right now it's being used primarily for criminal. But there are a lot of excellent civil attorneys that are pulling this data for civil uses. Your car has a black box in it if it's a relatively new car. I think it's 2004 and later. They all record black boxes. So if you get in an accident, we can pull that back. If you get in an accident, we can pull that black box data and we can determine how fast you were going, if you stepped on your brakes, whether you were driving aggressively at that time, if there was an equipment failure. We can tell all kinds of information from that black box. And in a civil case, especially if it's a wrongful death case, we can and will collect it and use it in the civil suit. So, and I'm a small-time attorney. I've got a small practice here in Kirksville. Okay, I assure you, the very, very large plaintiffs' firms are using that right now, and they're going to continue to do so. Okay, this electronic data collection is everywhere, and getting a hold of your cell phone data and your Google tracking information is part of the electronic evidence collection that people are doing for civil cases going forward. The cost of that is coming down across the board as well. So you need to think about exactly how much you want to carry that digital spy in your pocket, but also whether or not you want to request that your politicians start enacting some protections and some barriers. At the moment, the court is not really inclined to do a whole lot. Thank you for watching. Please hit like, subscribe. If you like what we have to say and you find it valuable, consider becoming a Patreon. Patreon.com/PatTalksLaw. We do appreciate your support, and we'll be talking to you soon.